In addition, my Lord, the application is presented in accordance with Section 15(1) of the TIA, and Section 37 of the Judicature Act. As well as rules 2 and 4 of the Judicature Criminal Procedure Application Rules, as stated on the face of the same. My Lord, they seek for orders that this court be pleased release them on bail.
Go ahead, Counsel. The system is recording.
Oh.
I'm not going to kill myself. Recording verbatim.
Gratitude, my Lord, for the technology. Thank you, my Lord.
We are about to become paperless.
Thank you, my Lord.
Soon not be proceeding with any
I watched with, my Lord, with joy as we launched the same. My Lord, the applicants seek to be released on bail, and the grounds in the application briefly as follows: that the applicants were arrested between 14th and 21st day of January 2026. They were arraigned before the Chief Magistrate in the Chief Magistrate's Court of Butambala and charged with 1 count of inciting violence, and that relates to the second to the 25th applicants. Incitement to violence and several counts of malicious damage to property. That the second to 25th applicants were remanded in Kawasa under government prison until the 3rd day of February 2026. That on the 21st day of January 2026, the first applicant was also arrested and subsequently arraigned before the same court on a charge of terrorism, contrary to Section 6(1) and 3(0) of the Anti-Terrorism Act. That the second to 25th applicants returned to court for mention of their case on 3rd February, and the prosecution dropped all the earlier charges of incitement to violence and malicious damage to property with which they had been charged before. And that upon dropping the earlier charges, the applicants, now all of them, the second to 25th, were joined with the first applicant and charged with terrorism. That the use offense is only triable by the High Court and only bailable by this Honorable Court. That the applicants have on several occasions appeared before the Chief Magistrate's Court of Butambala and have not yet been committed to the High Court for trial, and that no hearing date has been fixed for their matter on account of ongoing investigations. The applicants are antecedents and have never been convicted of any criminal charges, demonstrating respect for the law and their likelihood or assurance to comply with the bail condition. The applicants, my Lord, undertake to abide by all bail conditions that may be imposed and will not abscond from trial. The applicants, my Lord, are responsible citizens with permanent places of abode, and that the applicants have substantial sureties who they are willing to present and who are willing to be bonded by this Honorable Court to ensure attendance in addition to the applicants undertaken. That this court has this Honorable Court has the discretion under Article 23(6)(a) of the Constitution and Section 15 of the TIA to grant bail. And finally, my Lord, that it is in the interests of justice, fairness, and the constitutional doctrine of presumption of innocence that the applicants be granted bail. My Lord, in support of the application, all the applicants have individually attached and deponed affidavits in support. My Lord, I'll begin with your permission with the first applicant.
Yes.
The first applicant states that he's an adult aged 52 years. He's a senior citizen and a responsible citizen. He has rehearsed the same application which I have stated above. But in particular, he states that he has a fixed place of abode at Buate village in Kira municipality, Wakiso district, where he owns his own residence and runs private businesses. My Lord, at the time of filing the affidavit, the application, he states he was the Member of Parliament of Tambala County and was the chairperson of the Public Accounts Committee. He also has his ancestral home at Bugoye in Butambala district, a constituency that he represented for 15 years, consecutive years. My Lord, he states that he has good antecedents with no criminal record of conviction and a law-abiding citizen, and upholds the rule of law and the fervent that he said, that he has substantial sureties who are willing to be bonded by this honorable court, who include the Honorable Joel Senyoni Besekezi, leader of the opposition, whose national ID is attached with the NIN number. They also include his elder brother, his elder sister Sarah Lutaya, and his elder brother Admusa Lutaya, whose NIN numbers are also presented. My Lord, at an appropriate time, with your permission, we shall introduce them. It does undertake to honor all bail conditions that this court may be pleased to set as terms and conditions, and that he will continue to discharge his constitutional, if he hoped he would continue to dispose his obligations as a member of Parliament. My Lord, he has attached a letter from his LC1, Chairperson's Office of Water LC1, Chira Municipality, Wakiso District, dated that is 15th of April 2026, which is in the stamp marked as Annexure A1. At this point, my Lord, I think it suffices to make reference to the recently filed affidavit in reply, where the one DASP Rwebuga John Mary had stated that the applicant has not demonstrated that he has a fixed place of abode in his paragraph 8 in his affidavit. This is now controverted by the LC1 letter, which states that the Honorable Kivumbi is a resident owning a home at Palm Close, Buate, where he started staying in 2016. Indeed, my Lord, the Honorable Muwanga Kivumbi Mohammed as a residence that is attested to by the state in Annex B to the application, which is the charge sheet. The state itself states that he's a resident of Uwate village in Mikina.
First, they are talking about next year, but there's nothing like the marking of the document that I have. But I have seen a letter that is written in Kanji.
Yes, in Kanji Winters, my lord.
Okay, it's just marked it.
Sorry, my lord, for the mishap. But the next document to that is the national ID, which is mine is Annex A2, and then the next is the charge sheet.
Yes.
My lord, the charge sheet clearly indicates by the state itself that the Honorable Kivumbi is a resident of Uwate. And it is signed by the officer preferring the charge, confirmed by the magistrate and then the DPP. So clearly, the assertion that he has no fixed place of abode collapses, even with more so with the evidence of the state. My lord, later we shall introduce the sureties. If we permit, I will go to the next applicant. The next applicant, my lord, the next applicant, my lord, is Matov Buhan.